All right, I will call this meeting of the Senate Judiciary Committee to order. Will the secretary please take the roll?
Senator Harris, Senator Orenshaw, Senator Dondero Loop, Senator Wynn, Senator Hansen, Senator Krasner, Senator Stone, Chair Scheibel.
Here, we have all members of the committee present, so we definitely have a quorum. And just a quick housekeeping, in case you haven't noticed, we are in deadline season for the rest of the session. So I do know that senators will be coming and going off of the dais. Please don't take it as a sign of disrespect or inattention. They have other work sessions to vote on or bills to present, including myself today. I'll have to leave around 1:30, and our fantastic Vice Chair Harris will take over. That being out of the way, I also understand that the assembly is still on the floor, so we're going to have to be a little bit fluid with our scheduling here. We will start with AB 49, which is presented by the Attorney General's office and no members of the assembly, so hopefully they will be finished by the time we get to the other bills, but if not, we'll go to recess and work it out. And I also just wanted to remind everybody that in the Senate, we don't have rules about when you testify in terms of support, opposition, or neutral. You're all adults, and I trust you to come up at the time that you think is most appropriate. And maybe it helps to keep in mind that for us on the dais, when we go to vote on a bill, we only get two options, yes or no. So if overall you'd rather we press yes, come up in support. If overall you'd rather we press no, come up in opposition, and make your own judgments about how likely you think amendments are to be made or not made. And if you really don't care, but you do have something that you think would help us make a decision, come up in neutral and tell us what that is so you can help us make our decisions. And with that, I will open up the hearing officially on AB 49. Please go ahead whenever you're ready.
Thank you. Good afternoon. For the record, Heather Proctor, Heather Procter, Chief Deputy with the Nevada Attorney General's Office. Assembly Bill 49 seeks to amend NRS Chapter 34 regarding petitions filed by inmates after they are sentenced to a crime in Nevada. These petitions are referred to as a petition for writ of habeas corpus or a post-conviction petition. Under Chapter 34, there are essentially two categories of post-conviction habeas petitions, one in which the petitioners challenge their judgment of conviction or sentence, and second, in which the petitioners challenge the Department of Corrections' computation of time served. There are different procedural requirements for each depending on the type of petition filed. For instance, under existing law, petitions challenging the judgment of conviction must be filed in the county where the inmate was convicted, while petitions challenging the computation of time must be filed in the county where the inmate is currently incarcerated. And a petitioner cannot challenge both their judgment of conviction and time computation in a single petition. Unfortunately, these differences are sometimes buried in the fine print and can be difficult to navigate in practice. So the intent of AB 49 is to simply clarify the existing law as to the different procedures and requirements for the two types of petitions. This will make it easier for an inmate to properly file a petition without an attorney, for attorneys who litigate such cases, and for the district courts that address these petitions. First, we seek to clarify and distinguish the two types of petitions through sample forms. Existing law provides a sample petition challenging a judgment of conviction as found in Section 11 of the bill, but not to challenge the computation of time. Section 3 of the bill creates a form petition to challenge a time computation. You will also note the instructions to Section 3 are largely reflected in the revised instructions to Section 11 to more clearly advise inmates as to which petition to use based on their desired challenge. Second, currently in Chapter 34, the language as to which agency responds to such petitions is somewhat inconsistent and can be confusing. This confusion was intensified when the legislature in 2019 created a subtype of post-conviction petition known as a petition for factual innocence. To create clarity, Section 2 defines a prosecuting agency as the agency that prosecuted the crimes, and then we use that phrase throughout the bill. While the prosecuting agency is generally the county district attorney, the Attorney General's office is also authorized to prosecute certain crimes. By contrast, we did not change the bill that requires the Attorney General's office to respond to a time challenge calculation. Third, Section 26 repeals the existing requirement to file a return with the court. A return is a document prepared by the custodian of the petitioner, generally the Department of Corrections, that demonstrates the person is currently incarcerated or under supervision. As the responding agency to either type of petition, generally provides proof of a judgment of conviction and addresses the custody status of the petitioner in the normal course of litigating such petitions, there is no need for a return. Instead, we move to the requirement to provide proof of a judgment or custody to the responding agency's response or answer to the petition as reflected in sections 13, 14, and 16 of the bill. Fourth, with this wholesale clarification of Chapter 34, several sections include minor clerical changes to update the original language from the 1980s. Part of that change addressed the existing language that alternately used the terms conviction, sentence, and judgment of conviction. To be consistent as to the two types of petitions, we now use the term judgment of conviction or sentence for the first type of petition, and judgment of conviction only with regard to time credit challenges or when referencing the specific document, such as statutes that address timely filing of a petition, or in sections 9 and 8, as demonstrated in sections 9 and 18, and in the existing form in section 11 when the specific date of the document is required. Again, our intent is to use the consistent terms to easily identify which statutes or processes apply to each of these two types of petitions. I would note there was a rather large amendment adopted in the Assembly to AB 49, and that amendment was the result of working with shareholders to determine the proper language to use in this all-encompassing amendment. Finally, the Attorney General's Office submitted a new proposed amendment to AB 49, which we inadvertently left out of the original bill and the First Amendment. The new amendment addresses a provision in Chapter 178 regarding the custody status of an individual when a court grants a post-conviction petition. That statute addresses a petitioner's bail status when a habeas petitioner receives relief. Bail applies only in the context of a petition challenging a judgment of conviction or sentence, not a petition challenging time credits. Therefore, the intent of the amendment, consistent with the existing provisions of AB 49, is to provide clarity as to which type of petition such relief applies. In closing, AB 49 does not seek to change the law or procedural processes already in place for post-conviction actions. The purpose and intent of AB 49 is to clarify the differences between the two types of petitions and to provide guidance within the existing statutes to explain the procedural rules associated with each type. In doing so, AB 49 preserves inmate rights while promoting judicial economy and clarity in the law. Thank you.
All right, are you ready for questions? Okay. Members of the committee, do you have questions on this bill? All right. I don't see any questions, so thank you very much. And we will move to testimony. We'll start with testimony in support of AB 49 and invite anybody wishing to give support testimony in person up to the table in front of the room in Carson City. I don't see anybody in Las Vegas, so we'll start here in Carson whenever you're ready.
Good afternoon, Chair Scheibel and members of the committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. As I think most of you know, my day job when I'm not here is as the Chief of the Appellate Division of the Washoe County DA's office, and we do handle post-conviction litigation as well. This bill is going to clarify things for folks who are filing petitions in proper person. Because they do often file it in the wrong court, and then we have to move to transfer, and it delays the time in which they get a court to review whatever's going on with the calculation of their sentence. So we are in support of this bill. Thank you.
Tanya Brown, TONJA, BROWN, Advocates for the Inmates and the Innocent. We support this bill. We have also put in a proposed amendment to establish a factual innocence posthumously. What we've done was we just added a brand new section. We've gone with the current law on factual innocence and just applied it that way, but we've inserted where we thought the posthumous should go. It states that an act relating to criminal procedure, revising provisions relating to a petition for a hearing to establish the factual innocence posthumously of a person who claimed his or her innocence and has passed away prior to filing his or her actual innocence petition or motion for new trial, that prior to the decedent's death, the decedent became aware of newly discovered evidence that had been withheld either by the state's prosecuting agency, defense counsel, or the law enforcement agency due to his or her untimely death. No motions for new trial could be filed with the courts. Their representative may file a petition for factual innocence posthumously with the district court. Or if a petition for factual innocence or a petition for exoneration could be filed with the district court because no law had existed at the time of the filing or the Nevada Supreme Court found jurisdictional defect, their representative may file a petition for factual innocence posthumously with the district court and is appealable to the Nevada Supreme Court. The petitioner who is representing the estate of the decedent will be provided counsel at the state's expense. The decedent's representative may be his or her administrator, executor, relative, spouse, or attorney, becomes aware of the newly discovered evidence after the decedent's death and is in possession of that evidence or knows where that evidence can be found, may file a petition for factual innocence posthumously with the district court and may appeal to the Nevada Supreme Court. Under Section 17, under the NRS, we've added the word posthumously and decedent. Under NRS 34-921, factual innocence posthumously defined factual innocence posthumously. And we've kept the factual innocence law in effect. We've just added those words. And then under the section, we've added number 1, NRS 34 to newly discovered evidence defined, and then down to the added language we'd like to add. 1, that prior to the decedent's death, the decedent had become aware of newly discovered evidence that had been withheld by the prosecuting agency, but due to his or her failing health or untimely death was unable to file motions for new trial or petition for factual innocence. A, the decedent's representative, who is the administrator, executor, decedent's relative, spouse, or attorney, becomes aware of the newly discovered evidence just prior to or after the decedent's death and is in possession of that evidence or knows where the evidence can be found. 2, evidence that supports the claims of innocence with the Nevada Supreme Court appeal, oral argument proceeding on appeal, post-conviction petition, or writ of habeas corpus petition. Writ of mandamus petition that has been pending at the time of their death or unable to file the petition due to their untimely death, or whose petition had been exhausted or procedurally barred by the statute of limitations by the courts prior to the discovery of the newly discovered evidence that would have supported the petitioner, the decedent's petition of claims of innocence. And then we have added down into the NRS 34960, we've added under Section 1, at any time after the expiration period during the motion for new trial based on newly discovered evidence made pursuant to NRS 176.515, a person who is convicted of a felony may, and we've included new language, or the representative of his or her estate if he or she is deceased. And then on to the 3rd page or 4th page, we've added another section under NRS 341, Section 28. Section 4, we've added a Section 5, a brand new section, where it says, or the petition was denied and the Nevada Supreme Court noted a potential jurisdictional defect, Wilkinson versus State, November 28th, 2011. That gives a case where they are being denied because there's no law. And then we will skip to the last page of this, which was Section 28, and we've added Section 28.1, which is the section becomes effective July 1st, 2023 upon passage and approval. We've also provided, I have just provided you some of the reasons why we would like to see this. You have been provided an exhibit just recently. It is a motion for discovery in which you can actually see the handwritten notes of the prosecuting attorney. This came by way of a court order in 2009. The Honorable District Court Judge Brent Adams issued an order for Washoe County DA to turn over the entire file in this case. And when the file was turned over, there were over 220 documents, a lot of exculpatory evidence that would have exonerated him, not only that would have discredited the state's prosecution, all withheld in these witnesses. In fact, the courts still make decisions on the credibility of these witnesses. This information would have been crucial. And as you can see on page, the first one, and then on the second page, We have everywhere where he wrote okay on our motion for discovery, he turned over. Everywhere where he wrote no or showed no showing materiality, which was the exculpatory evidence, he did not turn over. And on the third page, it shows no showing of materiality. And then, again, I provided you with a court order. I did not name the case. And this here is a court order directing him in 1988 to turn over the evidence. And again, in 2009, it was shown he never turned it over. I can speak for some of the dead, but I think I've also provided you a copy of a letter. It's a note from the decedent. He predicted his own I'd like to read the whole thing, but I know that you won't allow me the time. But I just want to read just a couple little snippets. And I think who better well than someone who has been in this position, who's been wrongfully convicted of a crime they did not commit, and he would predict his own death. So he writes, when I first got to prison, I realized that if this could happen to me, it could happen to anyone, including family or other loved ones. I went to work in the prison law library, then took a couple of years of law through correspondence courses, as well as other offered by the state college system at the prison, and learned through research that it didn't have to happen if you know the law and how it works. So I took the case into my own hands and started from there. And then I just want to end with what he writes. I'm sorry. The simple truth is that because the judicial system in Nevada, as well as the parole board, are motivated by what is politically favorable rather than what is right, guilt or innocence is totally irrelevant to the process itself. The American public wants criminals in jail because they are tired of being afraid in the streets and tired of being victims. That fear causes the elected prosecutors to be entirely motivated to make certain that for every crime there is a criminal. As such, I feel the need to face the reality that I will spend the rest of my life in prison for a crime I did not commit, whether my life ends tomorrow by the act of another or in 20 years by natural causes. Signed, Nolan Klein, 28074, April 2001. He predicted his own death. But I will tell you this, prior to his death, he learned the truth about what they had done, the district attorney's office, and his current attorney at the time, and still now, was about ready to file motions for new trial and bail when we got word he had passed away. And this is another, there is no remedy unless the law changes. And the families are left behind and there's no moving forward with it, not really. I mean, you have no idea what it is. We become a victim of the system ourselves. It's hard to believe that I'm outspoken, but you don't know what happens at my home when I get phone calls from people, hateful phone calls from people, and I am because of what has happened. We want not just my family, but everybody else. We only know of one case right now. We do know that Nevada has posthumously exonerated 4 cases. 2 were from 1907, and they did it in 1987. For those crimes, and then the rest are judicially exonerated through, they had their cases pending, and because they were pending, they could be exonerated. But if they die, it's over. And I must say, and I would like to note that I was fortunate enough to be able to investigate and hire a private investigator and find the real perpetrator of the crime. In 2011. And I'd like to leave it at that. Thank you for your time.
Thank you. And I know that, hold on just 1 minute. I know that you reached out to most, if not all of us, with this amendment in advance. And I wanted to see if there were any questions from the committee, but I don't see any. All right. Thank you so much for your time and for your presentation. Is there anybody else wishing to give support testimony in person? Not seeing anybody, we'll move to the phones for support testimony on AB 49.
Thank you, Chair. If you would like to testify in support of AB 49, please press star 9 to take your place in the queue.
Anne Marie Grant, Advocates for the Inmates and the Innocent. I'd like to talk about our proposed amendment. I do support the bill, but I'd like to talk about our proposed amendment adding posthumous exoneration language to the bill. The AG's office has testified at Assembly Judiciary that they don't support the amendment of posthumous language because it changes the process. Truth be told, there are no other remedies or processes for those who died wrongfully convicted in prison currently available besides the legislature passing AB 49 with our amendment to add the posthumous language. The AG's attempt may be to clean up the language of the bill, but bills start off with that intent all the time, and we add to them to strengthen them to protect all Nevadans. We reached out to the AG's personal staff at his office months before the legislature began and asked for their input and to discuss and for their support on our amendment. We heard nothing back from them. The reasons the AG provided to Assembly Judiciary for not supporting our amendment is disingenuous. Even after death, there is a stigma attached to the surviving families that is ongoing and never lets up. The CIC unit in Washoe County does not give a fair review to those who have alleged prosecutorial misconduct. AG Ford himself said to Assembly Judiciary Committee during his presentation about the AG's office that their office seeks justice for all Nevadans, and testified that the committee that as a prosecuting agency, it is particularly important to him that when it comes to the criminal justice system and reform, the AG's office does not just talk the talk, they walk the walk. Our amendment AB 49 is the walk to that talk. Would we have said, oh, well, if DeMarlo Barry died in prison? What if someone you represented died in prison and you find exculpatory evidence after their death? Would you tell their family, so what? He's dead, it doesn't matter? A petition for exoneration posthumous was presented to the Nevada Supreme Court, and they opined, I quote, alternately, appellants suggest that as the highest court in Nevada, we should recognize a petition for exoneration even where the defendant is deceased, and presumably recognize that an order denying such a petition is appealable. We cannot do that. Contrary to the appellant's suggestion that this court is the only body in the state of Nevada that can set the course for petitions for exoneration after death, it is for the legislature to create a cause of action or a remedy and provide for an appeal. I'm asking you to please, I support this bill, but please add our amendment, AB 49. These families deserve justice. That is the ultimate injustice, dying in prison wrongfully convicted due to prosecutorial misconduct of withholding exculpatory evidence. Thank you.
That concludes all callers in support.
All right, we will move on to testimony in opposition to AB 49. I don't see anybody coming up to the table to give opposition testimony, so we will go to the phones, please, for opposition testimony on AB 49.
If you would like to testify in opposition to AB 49, please press star 9 to take your place in the queue. We have no callers testifying in opposition at this time.
All right, then we will move to testimony in neutral on AB 49. Anybody wishing to give neutral testimony is invited to do so now. I don't see anybody in person, so we'll go to the phone, please, for neutral testimony on AB 49.
If you would like to testify in neutral for AB 49, please press star 9 to take your place in the queue. We have no callers testifying in neutral at this time.
All right, would the sponsors like to make any closing remarks? All right, looks like we've completed our hearing then. I will now close the hearing on AB 49 and turn the gavel over to Vice Chair Harris.
Thank you, Chair Scheibel. We will go ahead and open up the hearing on AB 371 and invite up Assemblywoman Cohen. You all can begin whenever you're ready.
Thank you, Vice Chair and Committee. I'm Leslie Cohen, representing Assembly District 29. Joining me in Carson City is attorney Kimberly Surratt, who has practiced law for more than 20 years. Ms. Surratt has immersed herself in assisted reproduction law, parentage, and adoption. Ms. Surratt is a fellow with the Academy of Adoption and Assisted Reproduction Attorneys and is on the Board of Trustees for the Academy. Ms. Surratt has extensive knowledge in family law, parentage law, and surrogacy. Moreover, she served for 8 years on the Executive Council and has been vice chair and then chair of the State Bar of Nevada Family Law Section. In addition, she is past president of the Nevada Justice Association, having served on their board since 2013. She's lobbied with the Nevada Justice Association as an unpaid lobbyist since 2004, and her lobbying career is long, and she has worked on bills such as Nevada Domestic Partnership, the Uniform Collaborative Law Act, post-adoption contact agreements, a complete rewrite of all surrogacy statutes, and numerous other family law, reproductive, and adoptive statutes. So what we have here is the Uniform Parentage Act, and as a reminder, the Uniform Law Commission was established in 1892, and it aims to provide the United States, plus the District of Columbia, Puerto Rico, and the United States Virgin Islands with well-researched and drafted model acts to bring clarity and stability to critical areas of statutory law across the jurisdictions. The ULC promotes enactments of uniform acts in areas of state law where uniformity is desirable and practical. The ULC consists of approximately 350 commissioners, each appointed by the government of the United States, each state, the District of Columbia, Puerto Rico, or the U.S. Virgin Islands, and every ULC commissioner must be an attorney. Commissioners often concurrently serve as legislators, judges, or legal scholars, or members of staff for legislatures. In the realm of family law, Nevada has already passed Uniform Premarital Agreement Act, Uniform Deployed Parents Custody and Visitation Act, Uniform Interstate Family Support Act, Uniform Child Custody Jurisdiction and Enforcement Act, and the Uniform Child Abduction Prevention Act. So as you probably remember, and I've said it before in this committee, during my day job I practice as a family law attorney. Unfortunately, our family law statutes in Nevada are not particularly well organized or up to date. In some ways, they're really cobbled together, and they also don't always consider the way we create families these days. So the Uniform Parentage Act does just that. The Uniform Parentage Act was originally promulgated in 1973, and it removed legal status of illegitimacy and provided a series of presumptions used to determine a child's legal parentage. When the UPA was revised in 2002, it augmented and streamlined UPA from 1973. And the 2002 update added provisions permitting a non-judicial acknowledgement of paternity procedure that is equivalent to an adjudication of parentage in court, among other things. In 2002, it also included provisions governing genetic testing and rules for determining the parentage of a child whose conception was not the result of sexual intercourse. So in 2017, UPA was updated again and as a Uniform Law Commissioner, I was honored to serve on the drafting committee that worked for months on updates. And currently, so 7 states have enacted that 2017 update. Nevada is one of 5 state legislatures which have introduced the 2017 update this legislative session. 14 states have enacted prior versions. So before we go into the bill, I want to talk a little bit about the NRS chapter that the bill would go into. Mostly the bill is in Chapter 126, which is parentage. So very little of the bill deals with 125, which is where custody, divorce, and child support are. Parentage is how we determine who a parent of a child is, or who is a parent of a child. So if we have a married man and woman, parentage is usually pretty simple. However, if you have surrogacy, unmarried parents, or a same-sex couple, it becomes more difficult. So AB 371, the Uniform Parentage Act, works to simplify the process for the families, thereby keeping them out of court to address those issues. So I can do a quick walkthrough of the bill, and then Ms. Surratt will speak to the need for UPA in Nevada, if that would be okay with you, Vice Chair? Okay.
Absolutely.
I can do this walkthrough very quickly for such a long bill. So sections 3 through 26 relate to definitions. Section 27 and notes that any reference to mother or father includes any gender. Sections 28 and 29 note sections 27 through 91 are UPA and do not affect parental rights under the law beyond the act. Section 31 is jurisdictional. Section 32 is related to disclosure of information. Section 33 states what applies to the act for a mother applies for a father, and vice versa as applicable. Section 34 states now a parent and a child relationship is established, or how a parent and child relationship is established. Section 35 notes a parent-child relationship extends to every parent and child regardless of the marital status of the parents. Section 36 states a parent-child relationship applies for all purposes. Section 37 has the parental presumptions. The presumptions are rebuttable. Section 38 reference is acknowledgement of parentage to establish parentage of a child. Section 39 gives details regarding the acknowledgement of parentage. Section 40 addresses the signing of a denial of parentage by a presumed or alleged genetic parent. Sections 41, 42, 43, 44, 45, 46, 47, 48, 49, and 50 address acknowledgement and denial of parentage forms, including rescission. Section 51 permits the State Board of Health to adopt necessary regulations regarding the acknowledgement and denial of paternity. Sections 52 through 57 go back to definitions and begin the genetic testing section. And that goes through section 68 as well. Section 69 states matters to adjudicate parentage are governed by the Nevada Rules of Civil Procedure, except as otherwise addressed in the bill. Section 70 lists who can maintain a proceeding to adjudicate parentage. Section 71 lists who gets notice. Section 72 details jurisdiction. Section 73 details venue. Section 74 has to do with the report of genetic testing. Section 75 and 76 provide that a proceeding to determine whether an alleged genetic parent or presumed parent respectively is a parent of a child may be commenced after the child becomes an adult if the child initiates the proceeding. Section 77 lists who can commence a proceeding to establish parentage. And Section 77 of the bill authorizes a person who claims to be a de facto parent of a child to commence a proceeding to establish parentage of the child if the child is alive and less than 18 years of age. Also provides that a person who claims to be de facto parent of a child must be adjudicated as a parent of the child if there is only one other person who is a parent or has a claim to parentage of the child, and the person who claims to be de facto parent can demonstrate certain facts by clear and convincing evidence. Section 78 addresses the rules if there is a challenge and there is an acknowledged parent. Section 79 addresses a challenge to adjudication when a child has an adjudicated parent. Section 80 lists more proceedings to adjudicate. Section 81 of the bill authorizes a court to adjudicate a child to have more than two parents if the court finds that the failure to recognize more than two parents would be detrimental to the child. Section 82 allows for temporary child support. Section 83 permits the combination of proceedings. Section 84 permits the commencement of proceedings prior to the birth of the child. Section 85 permits but does not require a minor child to be a party and requires a guardian ad litem in certain situations. Section 86 requires adjudication of parentage without a jury. Section 87 addresses dismissal without prejudice. Section 88 addresses fees and the child's name change. Section 89 addresses who is bound by an acknowledgement. Section 90 refers to the importance of uniform law. Section 91 has to do with signatures. Section 92 relates to the death of a parent conceived by assisted reproduction during the period between the transfer of a gamete or embryo and birth of the child, etc. Section 93 addresses termination of the gestation agreement. Sections 98 through 106 of the bill make various other changes to the provisions of existing law concerning assisted reproduction and gestational surrogacy. In particular, Section 99 includes that a donor is not a parent of a child conceived of assisted reproduction, and the consent of a spouse or domestic partner of a donor is not required. Section 101 is failure to consent on the record does not preclude a finding of parentage if there is clear and convincing evidence of an agreement under certain circumstances. Section 107 addresses the requirements of an enforceable gestational agreement. Section 108 addresses the impact of the marriage or domestic partnership of the gestational carrier on the gestational agreement. Section 109 addresses noncompliance with the gestational agreement. And Section 135 requires LCB to make appropriate language changes. Then Sections 194 through 97, 110 through 33, and 36 of the bill make conforming changes to reflect the revisions made to existing law because of the establishment of the provisions modeled after those of the UPA in Sections 28 through 91 and the repeal of unnecessary provisions in Sections 136. And with that, I will turn it over.
I giggled last time I did this too because it's so long. Kim Surratt for the record.
Hopefully you have something to add.
Yes.
And not retread.
Yes.
Okay.
Big picture with all of this is that we have a mess. We don't have procedure. We make up most of this when we go to the court. We hope for the best, and for once, we might actually have some guidance for all of these issues. We have done massive changes over the years. I have worked really hard at picking and choosing bits and pieces of the UPA and bringing them in, and we've passed them all. But I didn't quite have the endurance to do this, to vet this through the family law section, which we have done, to make sure that the wording was right, because this was a lot. But we have done so, and we feel good about it now. We feel that this is something that will help the practice of family law for sure. Probably one of the best examples I can give is the scenario where a gentleman believes he is a parent of a child. He believes he's genetically related to the child. He raises the child for 10 years. And 23andMe or Ancestry.com comes along and they do a DNA test, learn somebody else is the genetic father. The genetic father comes in, wants to be a parent. We do not have answers under our law right now as to what do I do with the parent who's not genetic, and how do I bring in the now genetic father who has been out of the picture for 10 years. This allows for that. It gives us room without having to be relegated to the non-genetic father being pushed aside as a third-party visiting person who's not a parent. They will have standing as a parent under this law. And we can move forward for the best interest of the child, and this allows us to use the best interest of the child. The rest of it is just a whole bunch of procedures for my practice of law that I am just begging for, and so are the other attorneys that do this area of law. Who would think we'd want to be subject to this, but we do. And I can answer questions. I hope that was succinct enough.
Perfect. Committee members, do we have questions on any of the 150 sections in this bill? Senator Krasner.
Thank you, Vice Chair. Thank you for your presentation. And so this would only allow for more than two persons to be identified as the parents of the child when it is found by a judge to be in the best interest of the child. Is that correct?
Correct, yes. Kim Surratt, for the record, I'm sorry, through you, Vice Chair, to Senator Krasner. Yes, correct.
You can go directly.
Okay, thank you. It takes court intervention to make that determination, which is what we have to do right now, but then the judge doesn't have anything to lean on if we're making it up once we take it to the judge, and this will give us some guidance for that. You're welcome.
Additional questions? Of course, Senator Orenshaw.
Thank you, Vice Chair. I just want to compliment Assemblywoman Cohen. It's, we see uniform acts every session, but it's very rare that we have a legislator sponsoring a uniform act who's actually one of the authors. And I know how hard you've worked through different interims on the Uniform Parentage Act, and hopefully this passes here in Nevada and other jurisdictions adopted. I think it'll make the legal fights, I think, maybe less tough on everybody who's trying to get through the family court system, especially if there are children in other states. So thank you, Vice Chair. I just want to compliment Assemblywoman Cohen. Thank you, Mr. Rapp, for presenting this to the family law section.
Okay, with that, we will go ahead and take testimony, unless you want to.
Can I just add also, we do
Sure.
have a brief friendly amendment, so I just want to refer everyone to that. Also, I did receive notice from Bridget Duffy this morning. She did have some concerns about how this might impact 432B. Frankly, I haven't had a chance to really look at her concerns, but I'll definitely work with her and make sure that we don't have any issues, that we're not causing any problems for her office, for the DA's office in general when it comes to juvenile issues.
We don't tell on ourselves on the Senate side, so that's refreshing.
Oh, just in case you hear from her, we're working on it.
All right. Okay, with that, if you're ready, we'll go ahead and open it up for testimony. Anyone here in Carson City to testify in support of Assembly Bill 371? Go ahead and take your seats. Okay. All right, come on down, Miss Brown.
Tanya Brown, private citizen. You know what? It's a darn good bill. Thank you.
Okay.
All right, we support the bill.
Great. Anyone in Las Vegas not seeing any BPS? Can we check the phone lines for support testimony, please?
If you'd like to testify in support of AB 371, please press star 9 to take your place in the queue. We have no callers testifying in support.
Okay, great. We'll come back here to Carson City for testimony in opposition. Anyone here testify in opposition to Assembly Bill 371? Not seeing any, also still not seeing anyone in Las Vegas BPS. Can you please check the phone lines for opposition testimony?
If you'd like to testify in opposition of AB 371, please press star 9 to take your place in the queue. We have no callers testifying in opposition at this time.
Okay. Anyone for the neutral position here in Carson? Vegas, phone.
If you would like to testify in the neutral position for AB 371, please press star 9 to take your place in the queue. We have no callers testifying in the neutral position.
Okay, with that, we'll go ahead and close out the hearing then on Assembly Bill 371. Thanks for being with us. And open it up for public comment. Anyone here to give public comment? Okay. Las Vegas, not seeing anyone. BPS phone lines for public comment, please.
If you would like to provide public comment, please press star 9 to take your place in the queue.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis. He was hogtied for over 40 minutes and asphyxiated to death. I'm calling upon you as elected officials to do your duty and protect all the people in Nevada, and to call upon Attorney General Aaron Ford to use his authority under AB 58 and open an investigation into the Washoe County Jail regarding the constitutional violations that are occurring at the jail. My brother's murder received no death review by DA Christopher Hicks, nor did the asphyxiation death of Nico Smith and Justin Thompson. That would lead one to conclude that if you die at the Washoe County Jail while your constitutional rights are being violated, there will be no consequences for the perpetrators. I am calling to put you on notice about the crimes against humanity is what it boils down to that are occurring inside that facility as we speak. I don't know how anyone can turn a blind eye to it when someone is telling you what's going on. My family suffers an unimaginable, never-ending nightmare. My brother was robbed of his right to due process and his right to life. Act now before it's too late, and other community members in Washoe County lose their life at that disgusting, deplorable facility that is the Washoe County Jail. Thank you.
Yes, my name is Angela Campbell, and I am calling in regards to the Washoe County Jail. I am calling in regards to some of the constitutional rights that are not being honored there. And I'd also like to say that, you know, there are other things that are going on. There's mold that is on the floors, and it is not a sanitary environment. There is food that is not being inspected. There is medication that is not being given to the wards there. There is not extra clothing for warmth being provided. I think these need to be investigated, and some of the abuses that are going on. We are a group that is watching this, and we want there to be humane things that are put in place there, because some of the things are very inhumane, and we would like you to look into that. Thank you.
That concludes all callers for public comment.
Okay, thank you so much. With that, ladies and gentlemen, we will be adjourned. But before I gavel out, just a quick note. We are going to need to work session tomorrow promptly at 1 p.m. so that everyone else can leave and go and do their bill presentations as needed. So please try to have your butts and seats at 12:59. Okay, thanks. Have a great day, everybody. We're adjourned.